Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of Equitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're breaking down the most critical court cases shaping the fight against sexual violence, intimate partner violence, stalking, and human trafficking. Each week, we sit down with prosecutors and scholars to break down the decisions that define justice and to discuss the challenges that still remain. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Okay, hi, everyone. Welcome back to Just Champions. I'm so excited to be here with you all today because I am sitting with someone that I have many connections with, but I only just met formally this week, although I feel like our worlds probably collided at some other time, and that is Stephanie Fritz. And Stephanie has been a prosecutor for over 16 years. I mentioned we had these connections. She began her career at the Brooklyn DA's office in the Domestic Violence Bureau, where we know many of the same people, some former, some current people in the Brooklyn DA's office. So that was wonderful getting to pull that together. In 2014, she joined in Denver, the prosecutor's office there, the 17th Judicial District Attorney's Office in Adams and Broomfield County. And Stephanie created and currently oversees the Special Victims Unit, which is responsible for prosecuting sexual assault, human trafficking, and domestic violence crimes. She's handled hundreds of complex sexual assault cases and domestic violence cases to include domestic violence homicide. And in 2021, Stephanie was instrumental in creating her office's domestic violence high-risk team and co-founded the Human Trafficking Task Force and multidisciplinary teams. She also represents prosecuting attorneys on the Colorado Domestic Violence Offender Board and is serving her second term there. She regularly trains attorneys, law enforcement, and community partners nationally and statewide on investigating and enhancing domestic violence and sexual assault cases. Thank you so much for joining me, Stephanie. And did I mix up a county? Tell me, did I get something wrong?
Well, our county is just north of Denver, so we are Denver adjacent. And thank you for having me. It's such an honor to be here and to have this time to talk with you.
Okay, now, and I'm so honored to be here because your background makes you the perfect person. I mean, you've done just in learning about and listening to myself talk about your history of prosecution. One of the crimes that intersects domestic violence, human trafficking, sexual assault so frequently is stalking. And yet we still hear, even with all of the attention, all of the laws across the country, that sometimes it's an overlooked crime. And so often it's a minimized crime. So I'm really grateful to be able to talk to you about your specific experience with stalking and threats and how those play out in your cases.
Yes, that is all true.
So can we talk about that? They are so often minimized, but they truly terrorize victims. Can you talk about your experience, what you're seeing in your cases, how stalking intersects with the crimes that you prosecute?
Well, we see stalking intersecting in the majority of our domestic violence cases. And to your point, it's not caught, it's underreported. We oftentimes will see multiple protection order violations filed and jurisdictions were not good at catching it as stalking, or perhaps she's being stalked and contacted in one city at her office and she lives in another, and then the two jurisdictions aren't communicating. So we see it that way. And I also think with the increase of technology, I think we're seeing it in many different forms, and we're not as great at catching it. The offenders are ahead of us in the use of technology. And so we're doing a lot to educate ourselves on the technology and to better understand it so we can catch it.
So you're obviously catching it because you're seeing it in your cases. Can you talk about, let's start with, and I know technology is everywhere, so it's hard to think about how it isn't arising in these cases, but obviously there are some unique issues there. I hate to use the word typical, but in your domestic violence, sexual violence, human trafficking cases, how are you identifying stalking in there? How are you and the law enforcement that you work with identifying it?
Well, we have to rely on the victim's report, and we have to train officers to ask the right questions to elicit the stalking, because a survivor may not be focused on that part of the criminality. But we see it a lot with text messages, the use of social media. We're seeing more and more GPS units placed on vehicles and spyware apps being placed into phones.
What are the issues that you're focused on as a prosecutor when you know you're having a case involving, say, a GPS or some other tracking device?
Well, the first issue is locating the device. That's the first issue we encounter. In our jurisdiction, our officers are getting very good at looking and scanning vehicles. Oftentimes, we'll see it placed in the car. And you have to be careful, too, where you're looking for it, because if you have her go to the police department, then the stalker will be alerted that she's interacting and reporting it with the police. And we have to be careful, too, when we're searching victims' phones, because in our jurisdiction, if we were to download a complete download of the victim's phone, we have to discover it. And that is just a calling card of harassment that we would have to give over to the stalker. And so we have to be mindful of the unique issues in our discovery obligations to protect the victim as well.
Hey, folks, Jennifer here. I'm just jumping in with a little bit of background info on this topic. Prosecutors have an ethical and legal duty to disclose any potentially material or exculpatory information to the defense. And this is a practice which supports the achievement of a fair and just case outcome. Now, balanced against this is a victim's legitimate right to privacy in data existing on their phone that's unrelated to the case. So prosecutors can reconcile these interests in several ways. The scope of data obtained from a victim's phone can be narrowed by specifically targeted time periods or other relevant limitations that are based on the circumstances of the case. So if it's not technically possible to limit what data is obtained from the victim's phone, then prosecutors can limit disclosing to the defense only what data is material or exculpatory. However, when prosecutors have limited the scope of data obtained or disclosed from a victim's phone, the defense must be put on notice of those limitations so that they can pursue options to ask a court to determine if the disclosure is too narrow. Prosecutors should be prepared to litigate pretrial motions before the court to protect against disclosure of any immaterial and irrelevant data that would unfairly compromise a victim's right to privacy. So what I'm saying is, prosecutors should never hide the ball with discovery. It's obligated to disclose, or even whether potentially relevant evidence exists. However, prosecutors must also recognize the inherent risks of privacy exposure that victims may fear with the vast amount of personal information on a smartphone that may be unrelated to a case. Okay, let's get back to Stephanie. You know, you raised two really interesting issues there. I want to start first with the discovery of the GPS. Is this something that's you talked earlier about asking the right questions and training police officers. Is this something that your office and your partners in law enforcement are proactively looking for and you're raising the issue of a GPS? Or are victims coming to you and reporting facts or circumstances of the crimes being committed against them that are indicating to you that there might be a GPS or other tracking device?
I think it's both. I mean, typically victims know. There will be a message. How does he know that I'm at this place? How does he know what I'm saying to other people or how I'm communicating via email? And so there is some indication there. And we spend a lot of time training law enforcement officers. And we're lucky enough in our part of our high-risk team, we have an investigator, Brian Vandermeer, who is super aggressive about following up with victims, taking what they're saying very seriously, and following up and doing those types of investigations.
So it sounds like the minimization that, we hear about that sometimes happens is not, it's something that you and your partners have really fought hard to make sure is not happening in your counties.
Yes. We've even embedded in our form, our domestic violence case investigative form, we have a section of questions that we ask every patrol officer to ask domestic violence victims. Have you been subjected to unwanted repeated conduct? We don't call it stalking in case it's not been labeled as stalking, so we don't miss it. Have there been multiple protection order violations in the past? And so we're asking those questions, and oftentimes we'll catch it and see what follow-up will need to be done beyond the patrol initial investigation.
And, sometimes we hear that, victims are part of the public and the community too, and can sometimes, they're very good reporters of the facts that they're actually experiencing, the details, maybe that we would call them the elements of the crime, but they often underestimate the danger that they're in. Our stalking crimes, and we know that they're highly dangerous. On risk assessment, stalking is a lethality factor. Can you talk a little bit about what concerns you when you identify stalking as part of your cases?
Well, we have a saying in the special victims unit, stalkers are going to stalk. So they don't stop. It's this relentless crime where there's no peace for the survivor. And so that relentless, very hyper-focused behavior is really concerning. And it is a lethality indicator. I've recently handled a homicide where he stalked the victim prior to committing the homicide. So I've lived that high lethality. We've had offenders who've committed suicide during the stalking behavior, which again, the suicide is a high risk for lethality. It always makes us very nervous when an offender is threatening suicide. And so we see it in our lived cases playing out.
And I'm so glad you raised that issue in the domestic violence homicide. I mean, we see this in sexual violence homicides too, and always why it's so important when you're getting the information ahead of time to be taking it seriously. And also, it becomes part and parcel of the case. A lot of the facts that make up a stalking case are also very relevant to our domestic violence cases or human trafficking or even in the homicide. And I think sometimes when people aren't prosecutors or lawyers, they may not you're focused on the issue that you had, the crime that you have in front of you, and not all of the other information about the relationship or other abuse that's happened is quote unquote seen as relevant, although we know it very much is relevant because it builds the violence of the relationship and leading up to the crime. And stalking, in addition to really revealing the entire relationship and entire abuse, revealing the full experience of the victim, it also serves as a very important tool to helping us introduce other avenues of introducing some of this evidence of other bad acts, other abuse that we might have to look under certain rules of evidence to come in. But when there's a stalking crime, we can bring more of that in. Have you had a case like that? Can you talk a little bit about that legal tool?
So since the conduct is repeated, you have to have multiple contacts. That allows you to expand your date range initially. So you can go back to the communications and decide when is the best starting point. Oftentimes, too, what we see in stalking cases is since the behavior is not stopping, do we expand it as it happens? Do we file new cases so that we're getting increased bonds so we have containment and safety for the victim? And all those different factors. It's a continuous, they're live breathing cases that there's not just a crime and it stops and we're done. And so there's a constant shifting and reviewing of the evidence.
Do you find that your judges and your juries are understanding these stalking cases? I mean, when you're planning your opening, when you're planning how to put the evidence in, what are the types of things that you're thinking of to help persuade the fact finder about the dangerousness of these type of cases, the credibility of the victim, the importance of these cases? How do you prepare?
Well, most cases that I bring before a jury, I will engage with an expert on the particular case, whether it's sexual assault, domestic violence, stalking, and we'll talk about the misconceptions that the general public have about that crime. I think one misconception that is held by many is that a victim might continue to communicate with the stalker, and that doesn't mean that she's not being stalked, or that a victim can be stalked by an offender who's in custody. We filed cases where victims have been stalked while he's in custody on bond, and everyone said, "You're crazy." And I'm like, no, you can absolutely stalk someone from inside. And we were successful, and the judge luckily understood and sent that individual to prison. But I really do think that ongoing communication, which is really important for a survivor to know baseline, are we safe? How organized is his thinking today? Can I go ahead and do my daily errands and know that I won't risk being harmed or followed? And so I think that's really a tool of protection for a victim. And I don't think the general public understands that, or juries. And I also think trauma in the brain, the retelling of what a person is experiencing, it's not linear. And so having an expert explain that to a jury is really important.
I'm just thinking about something you said earlier in our conversation about preparing for these cases. And just your response now really brings me back to it, because we talk about being victim centered, but a lot of the things you said really are. I mean, you're the prosecutor, you're trying your case, but it's so clear also you're thinking about the impact to the victim, thinking about impacts on victim privacy when we're talking about discovery obligations. And when you have a victim's phone, is that really the best source of evidence? And it's, as prosecutors, obviously we're searching for the truth, but going into a victim who's not, accused of committing any crimes and downloading, and we know on our phones, and, recent court cases have shown us phones, they're more than a digital wallet. They can be really just a digital blueprint of our lives in some ways. So much of what we do is on our telephone. And I think having that sensitivity of, can I get this evidence? Should I be thinking about a search warrant for the perpetrator's phone? Should I be thinking about other avenues of evidence? If I have a victim's phone, can I limit what I am taking so it's relevant to this case? And when there are revelations, going to the court to say, look, we have a lot of information here. A lot of it is not relevant. So I'm going to go to you, court, and do a motion in limine to say, here's what shouldn't be passed over. I mean, I think what you were saying was so incredible. And I wonder if you have any thoughts on that.
Well, I think to ask the court to do the in-camera review of a victim's download phone is unwieldy. And I've had that situation where we've done that. And there's too much data for a judge to sift through. And also prosecutors or the bench, we might not know what's relevant or what the defense attorney considers Brady. And so we have to be mindful of that as well. I had a case where it was litigated all the way to our Supreme Court about whether we had to turn over the phone dump. And so I'm not comfortable with that. Where our office, through Kathy Hansen, is looking at different technologies where we're just really being able to focus on the download of the victim's phone that's relevant to the stalking case. We frequently will employ search warrants for the defendant's phones, and we've used other technologies like Nighthawk and things like that to help us synthesize all of that data. And going into also Facebook records, Instagram, Snapchat, and things like that on the offender's account. One thing that gets so frustrating about stalking is that the onus is always placed on the victim to investigate her stalking or to provide us that information. And so we try to do our best to minimize that, because that's not fair to her either.
No, and that's fantastic. And you raised a lot of other tech-specific considerations when you're preparing or when you're investigating a case. Can you talk a little bit about what you're thinking about when you're looking into a perpetrator's Facebook or Instagram or other accounts? Are there considerations that you have, ethical considerations on the investigation or prosecution side that you could talk about a little bit?
Well, we just have to be mindful and narrowly tailor our search warrants to our crimes and our date ranges. But that's a challenge in of itself, because as we've been talking about, stalking is not just one moment in time that we can go in and get the phone. And so or the data. So there could be relevant information beyond the stalking time that you're aware of. And so that's a challenge and a consideration in drafting our warrants and our nexuses to the data that we need to consider.
Have you had challenges to those warrants, and how have you overcome them? And just, again, understanding there's a lot of maybe different experience levels listening to the podcast. For a search warrant, I mean, the review process, you're stuck with the four corners of that warrant and what's inside, right? So can you talk a little bit about that?
I think the courts are grappling to keep up with the technology too, and it's a developing area of the law when you're searching electronic data. It can be challenging because things that we think we're doing that are permissible in the moment may turn out to not be. in a couple months once there's a review of a Court of Appeals decision. So that is an added layer and challenge, making sure that our warrants are drafted in such a way that it can sustain appellate review. And so we oftentimes will have that added layer of litigation in our cases that are stalking.
Now that we're talking about that threats, I feel like it's a good time to transition over into the case of the day we usually have, or cases of the day here. And there are two. One has a domestic violence component. One has a, I would say, violence against women component to it. For this first case, the Elonis v. United States, these were threats. And while one of the defendants, many victims, was his ex-wife, this was charged under a general interstate communication statute, a federal statute, in fact. And I like to point these out because I always feel like twofold. One, these Supreme Court cases, and I know you and I talked about this before, there are so many significant Supreme Court cases that impact communication, First Amendment, mens rea, the way we break down if someone is culpable for a crime and what level of communication is criminal, if you will. And many of them come from domestic violence or violence against women focused crimes. And, at the appellate level, people sometimes forget about the original trial, and sometimes the facts are laid out. And in both of these Supreme Court cases, they were.
The facts are outrageous. They're astonishing. So
it's fascinating. And again, it's, I think as lawyers, we sometimes, or maybe it's non-lawyer, the public, you sometimes take for granted what, we talk about over-criminalization all the time. But the important part to remember is the system of ours, which has come under a lot of attack recently, but it really has mechanisms in it, if you will, to protect individuals, to really protect their rights and to have a process where a defendant, again, any defendant, wherever they are, has the opportunity to have appeals. And those appeals sometimes go up to the highest court of the land. So in Elonis, this was an individual who used Facebook to throw out highly violent rhetoric under the guise of art and lyrics. And I guess that was the crux of this. He had been very specific in his trial. The reporting was that many people, from his ex-wife to neighboring schools, co-workers, to ultimately an FBI agent who came out to investigate him, were all loose targets in Facebook postings with a lot of violent rhetoric. I don't think that was in doubt. But the court really went back to look at the law and look at what would be fair to people and how to protect actually protected speech, which threats are not protected speech. But the court was very meticulous in going back and saying, it's not really about what the reasonable person would feel. It's about proving what a defendant meant.
What struck me when I was reading Elonis is that had there been a mens rea attached to that prosecution, I'm almost certain that the prosecutors would have prevailed. And so it's just kind of cleaning up the law to ensure that we are protecting free speech while still protecting victims. But it can be very scary when you're reading it and seeing that the case was overturned.
And I guess even when the laws, so we're always here at Equitas, we think, okay, sometimes the laws are imperfect, but we can still find a way. Even with a perfect law, you're still going to have to argue through all the posts that this perpetrator has an intent. And we're always thinking, okay, defendants don't walk around. I used to have a mentor, Vernon Chestnut, who said defendants don't walk around with intent, their intent stamped on their forehead, but you can see it in their actions for someone like the facts in Elonis. So in Elonis, the Supreme Court held that the prosecutor had to show that the defendant intended to be threatening or knew that their conduct would be viewed as threatening. So hypothetically, if you are trying a defendant who committed the acts that Elonis did, what facts would you look at to prove this?
First of all, he had a protection order. So there was a court intervention that wasn't causing him to stop with, as far as the domestic violence. piece. And so I would look to the words themselves to argue his state of mind. But in the domestic violence, stalking, and human trafficking cases, I think it gives us a stronger argument to bring in those prior bad acts. What was happening in the relationship before to explain why this innocuous communication is actually really threatening, and his behavior before helps inform his mens rea now. And so I think that gives us stronger arguments to be able to give a jury a fuller picture of what's going on.
I love this. I feel like we got into the mind of the prosecutor. Like you actually, like, this is what happens. You get a report. And of course, we have discovery, but a lot of the reports we get as prosecutors, you're getting the initial reports. Maybe you'll have a patrol report and detective. You may have some statements, some reports from the detective. You don't always have everything. And then even when you do, you're going through meticulously and thinking, okay, what are the facts telling me here? What's the full picture? And how am I interpreting what's happening? And Counterman v. Colorado is the second case. And again, I do think that they're related, even though Counterman, it was not domestic violence. But I was so excited to have you because you are from Colorado. And I know not every prosecutor in Colorado's like one doesn't speak for all of them, but you all went through something. And I wondered if you could talk about this case. Also shocking facts. And then I have some questions for you.
Well, I remember when I first heard about Counterman, I think it was when it was pending, maybe cert had been granted in the Supreme Court. So the New York Times had run a piece on that victim. And I just remember thinking how scary what she's experiencing and feeling and how it so impacted her life. It also impacted me. After Counterman was decided, I had a case overturned. There was no way I could have done anything differently, not knowing that Counterman was coming, invalidating that statute. And so in Colorado, we have two stalking statutes. We have extreme emotional distress, and we have one that's credible threat. And so our stalking statute that is a credible threat, there is a mens rea. It's knowingly make credible threats. And so that wasn't the one that's at question. It wasn't affected by the decision. The one that was affected was repeatedly follow, contact, some other things, or make communications in a manner to cause extreme emotional distress. And so there was no intent tied to the communication piece of it. It was just that it was made. It was a reasonable person standard for the communications, and then a reasonable person would suffer extreme emotional distress. And so the court overturned the case saying that we had to have that reckless mens rea when it's a stalking prosecution based on true threats under our extreme emotional distress statute. What I found, and as a prosecutor with my similar case, what I find, it's not necessarily always the content of the communication. It's that repeated conduct, that repeated contact. And that's what I found so frustrating. It's the continuously, like, in Counterman, she was a musician. She had never even met him. He would send her repeated text messages. She would block him on Facebook. He would just create new Facebook accounts. He insinuated that he was watching her. He knew the color of her Jeep, would provide details about her personal life. And it's not necessarily always the content of the communication. It's just that it's relentless. It won't stop. There's this implication that he's surveilling her. And that in of its alone is scary. It's the conduct, not the content of the communication necessarily. And so that's what I found frustrating with the decision. There's a case in Maine that does an excellent job post-Counterman of articulating that it's not always the expression of the content by the defendant that is the basis of the stalking charge. It's that act of that repeated unwanted communication and just really distinguishing the two. And I think that's what we need to do now as prosecutors, is distinguishing the repeated conduct.
Yes. And in this case, I mean, I think you mentioned it. In this case, there were hundreds of Facebook posts. He was blocked and created new Facebook accounts. And I think it should be obvious how terrorizing that fact is of just incoming messages from someone who you don't see. And it is terrifying. It's terrifying to think where they are you just not seeing them because they clearly know a lot about you in that case. And I wonder, have we moved you talked about, I think earlier on this podcast, how sometimes judges and maybe even juries may not, may need to be educated about evolving technology. Facebook's been around forever, but do you find you still have to explain to people why posts on Facebook aren't, like, the victim is not responsible for reading those posts and somehow for that abuse that is incoming to her?
Absolutely. I don't think you can take anything for granted. I mean, our burden is so high, it's beyond a reasonable doubt. So you would want to explain that. And in particular, if you have an older jury, then you might need to do it. The technology piece might be something you would maybe want to spend time with during jury selection, speaking to the jurors to ensure that they're comfortable with technology if you know you're going to have a lot of that type of evidence.
Do you still have judges, or do you still worry that juries might think, well, look, why doesn't she just get a new Facebook page? Why didn't she not open up Facebook if she's so scared?
I absolutely always worry about that. Well, in particular, it's very difficult in domestic violence cases. So say there's children, maybe the court has ordered some communication about the children, and so that adds a layer of complexity to the stalking behavior as well. And again, like we talked about earlier, if a victim is communicating with them as a survival mechanism or because the court has ordered them to, then that makes it difficult too. And so I do worry about juries not understanding that.
When you're trying the case, what do you do to overcome those really unfair determinations, but those defenses nonetheless that can interfere with a finding of beyond a reasonable doubt?
If there is a history of the relationship, if gathering those prior bad acts and doing an extensive interview with the victim to gather that information, and maybe there's other people you can interview, outcry witnesses, other people who are aware of what's going on. And so you can build up some evidence that way. And so it's not just falling all on the victim. It's a retelling of what she experienced. Again, I think experts are crucial in explaining this counterintuitive behavior. And so that's kind of how I approach it. And then thinking of what digital warrants we can do and things like that.
And I think, too, you're just proving, too, why the stalking charge is so important, because it is repeated conduct. So you're going to be putting that evidence in to prove that stalking charge. And that's, I mean, it's not it is a legal strategy, but it is a legal strategy only to get to the truth, because that is what the abuse looks like. It's everything. It's the incidents in the moment and the stalking and the terror and the fear and the unwanted contact that's happening over and over and over again. And you have a chance to lay that in and tell the victim's story.
Yeah. And all the victim wants is it just to stop. They just want the communication to stop.
I love that. I love ending there, because I think we do always want to come back to why we're doing this. We're doing this to keep victims safe, to keep communities safe, to respect this balance between fairness and remember that it goes both ways. It's due to the victim as well. And certainly so much of what you said on this podcast underscored that as well, too. So I really, really appreciate that. As we talked, I think so much of prosecution, and I think so much of what you do in your jurisdiction. So I wondered, I have 3 quick questions. I wondered if you could talk about the hardest lesson you've ever learned in a courtroom.
I'm going to go back to actually my very first trial. I was a brand new baby prosecutor, and it was really hard to get cases off the ground to trial sometimes in Brooklyn. It was probably a stalking case that came through as harassment. Now I know what I know. And it was just unwanted communications. And we often hear that stalking makes victims feel like they're crazy. And so she felt that way. And I really wanted to prep her and prepare her to testify. And I was told, no, don't talk to her. You're nervous. She's going to get more nervous. It's going to be a disaster. Well, it was a disaster because I didn't talk to her. I didn't prepare her. We put her on the stand. She had a complete trauma response where she froze and she couldn't remember what she had experienced. And it was because I failed her. I didn't efficiently prepare her to testify. And I had no idea what I was seeing was a trauma response. And I always think back to that first case and how much I've learned since then and how I better serve survivors today. because that was one of the worst experiences.
What would you tell young Stephanie about this work?
To just stay with it. It will be very, very rewarding. And to listen, always listen.
And what keeps you coming back to the work even when it's tough?
Oh, it's hard to say. I love prosecution. I love prosecuting violence against women. It's my life's passion. I think just helping folks. The criminal justice system is so scary. It's so triggering. It's so re-traumatizing. And just learning how to do it better and to really help survivors get that procedural justice that's not always present is why I keep coming back.
I'm so glad you keep coming back. And I am so glad that Kathy introduced us and now I know you because I'm definitely coming back to you for lots of questions that I might have, but mostly to thank you for everything you do. Thank you so much, Stephanie.
Well, thanks for having me.
This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about Equitas, please go to equitasresource.org. That's AEQUITAS resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, Equitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.